Hello everyone, and thank you for your time for joining me today. Today's daf is Shevuot daf 35 Omadei. Let's dive straight into the Gemara answers. For that reason, the Mercer one writes, the verse with regard to an oath of testimony near the verse with regard to an oath on an utterance, and near the verse with regard to defiling of the temple or the sacrificial food, as in all of those passages is stated concerning them, and it is hidden. And here with regard to an oath of testimony, it is not stated concerning them, and it is hidden. The Torah did so to underscore the contrast between them and to deem liable one who takes an intentional false oath of testimony like one who takes an unwitting false oath of testimony. The Mishnah, if one said to witnesses, I administer an oath to you concerning your refusal to testify that if you do not come and testify on my behalf that so-and-so said he is going to give me 200 dinars, she'amar ish peloni liyiten li. Even the plaintiff said to witnesses, I administer an oath to you so that you will come and testify on my behalf that so-and-so would give me 200 dinars, and he did not give it to me, and they deny knowledge of the matter, they exempt from liability for taking a false oath of testimony, because even if they testify, the defendant would not be liable to pay based on a statement that he would give money to the plaintiff. 10:2. And dinars, and he did not give them to me, and they take false oath that they have no knowledge of the matter. They are exempt from liability to bring an offering for taking a false oath of testimony, as one is liable for taking a false oath of testimony only in a case involving a monetary claim, like a deposit, in the sense that they were witnesses to testify. The individual will be liable to pay. In the case of a promise to give a gift, he could claim that he merely reconsidered. If one said to witnesses, I administer an oath to you that when you will know testimony relevant to me, one administers an oath to witnesses and tells them that when they will discover information relevant to testimony on his behalf, they will come and testify, and they answer Amen. And therefore they discover relevant information, and he demands that they testify, and they deny knowledge of the matter. They exempt from liability for taking a false oath of testimony because the oath preceded the knowledge of the matter. 978. You will come and testify on my behalf. The witnesses are exempt from liability for taking a false oath of testimony, even if they do not testify, due to the fact that the oath preceded their knowledge of the relevant testimony. If one stood in a synagogue, witnesses are not liable for taking an oath of testimony until the plaintiff specifies and ministers an oath to them. If one stood in a synagogue and ministered an oath that anyone who has knowledge of the matter will come and testify, and all those present answered Amen, including those who are witnesses, and when he demands that they come and testify, they deny knowledge of that testimony, they exempt from liability for taking a false oath of testimony, since he did not specify them as his witnesses. If the plaintiff says, I administer an oath to everyone who is standing here that you will come and testify on my behalf, and among those standing were witnesses who had information relevant to testimony on his behalf, and they later denied knowledge of that information, they are liable for taking a false oath of testimony because he specifically designated them together with all others present, in accordance with the Mishnah, the Brisa, and the opinion of Shmuel. 9:9. And said for all to hear, I administer an oath to you that if you know my testimony relevant to me, you will come and testify on my behalf. These witnesses are exempt until he directs his demand to specific individuals. If one said to two people, I administer an oath to you, so and so and so and so, if you know testimony relevant to me, and you will come and testify on my behalf, and they respond, on the oath we do not know any testimony relevant to you, and they know testimony relevant to him, not based on an incident that they witnessed, but based on hearsay testimony, aid me p aid v'chudu, hearsay testimony, etc. If one of the witnesses to whom the oath was administered was a relative or otherwise disqualified from testifying, and even if his disqualification was by rabbinic law, not by Torah law, or if their testimony was based on hearsay and they denied knowledge of the relevant matter, they are exempt from liability for taking a false oath of testimony, because even if they testified, they would be unable to render one liable to pay. And that's the Rambam Sefer Shevuot 10:1. Which is not valid testimony, or if one of the witnesses is found to be a relative or disqualified, Korav or Apostle, a relative or disqualified. Close relatives may serve neither as witnesses nor as judges in cases involving a family member. Two judges or two witnesses who are related to each other are similarly disqualified. They are disqualified whether their testimony or judgment is in favor of their relative or against him. In this context, a close relative is defined based on the number of generations that separate the judges or witnesses and their common relative. Two brothers are referred to as first generation to first generation. They have a common father. Whereas cousins are called second to second, they become a grandparent. An uncle and nephew are first to second, and so forth. Everyone agrees that relatives who are second to second or closer are disqualified from serving as witness or judge. Some authorities disqualify even more distant relatives. Husband and wife are not considered relatives. They are considered to be the same individual. Relatives are disqualified from testifying against one spouse, are also disqualified from testifying against the other. Witnesses who are disqualified are those who committed a transgression. Anyone who violates the Torah prohibition is disqualified until he repents. That is the case with regard to both prohibitions between man and man and those between man and God. Those who have a vested interest in the outcome of the case being adjudicated are also disqualified. The sages disqualified those who violate rabbinic prohibitions to those who earn their livelihood from morally dubious occupations, gamblers, and those who conduct themselves in public in an undignified or self-abasing manner. Those witnesses are exempt from liability for taking a false oath of testimony because they are unfit witnesses. If the plaintiff sent the demand for their testimony by means of his slave, or in a case where the defendant said to the witnesses, I administer an oath to you that if you know any testimony relevant to the plaintiff, that you will come and testify on his behalf, and they took a false oath that they have no knowledge of the matter, these witnesses are exempt from liability for taking a false oath of testimony until they will hear the demand to testify directly from the mouth of the plaintiff. As to Yishma'u mipi hatoveya. If the defendant administered an oath to the witnesses that they have knowledge of the matter relevant to testimony on behalf of the plaintiff, they should come and testify, and they deny knowledge of that matter, they are exempt from liability for taking a false oath of testimony. They are liable only if the plaintiff administers the oath. Needless to say, if a third party administers an oath to witnesses and they come and testify on behalf of the plaintiff, the defendant owes him money and they deny knowledge of the matter, they are exempt from liability because the plaintiff did not demand their testimony. And that's from the Rambam Sefer Shevuot 9:7, Shulchan Aruch Mitzvot 28:1. The Gemara cites proof for the halachot on the Mishnah from verses in the Torah. The sages taught, I administer an oath to you concerning your refusal to testify. If you do not come and testify on my behalf that so-and-so said that he is going to give me 200 dinars, and he did not give them to me, in such a case one might have thought that they would be liable. Therefore the verse states the term shall sin with regard to an oath of testimony and shall sin with regard to an oath of a deposit in order to derive a verbal analogy. Here it is stated with regard to an oath of testimony shall sin in Leviticus 5:1, and there it is stated with regard to an oath on a deposit shall sin in Leviticus 5:21. Just as there with regard to an oath on a deposit, the verse is speaking only with regard to a monetary claim, and in a case where the plaintiff has a legitimate claim. So to here with regard to an oath of testimony, the verse is speaking only with regard to a monetary claim, and in a case where the plaintiff has a legitimate claim. In the case cited in the Braita and in the first clause of the Mishnah, the plaintiff does not have a legitimate claim. The Mishnah teaches, I administer an oath to you that when you will know testimony relevant to me, you will come and testify on my behalf. The sages taught, I administer an oath to you that when you will know testimony relevant to me, you will come and testify on my behalf. In such a case, one might have thought that they would be liable. Therefore, the verse states, and he heard the voice of an oath, and he is a witness, or he saw, or he knew. Leviticus 5:1. One is liable to bring an oath, an offering for false testimony, only in a case where knowledge of the testimony preceded the oath, and not in a case where the oath preceded knowledge of the testimony. The Mishnah continues, if one stood in the synagogue and said, for all to hear, I administer an oath to you that if you know testimony relevant to me, you will come and testify on my behalf, these witnesses are exempt. Shmuel says, that is the halacha even if his witnesses were among the people in the synagogue. The Gemara asks, isn't this obvious? Otherwise, there would be no novel element in this halacha of the Mishnah. The Gemara says, no, it is necessary to cite this case only in a situation where he's standing right next to those witnesses. Unless you say he's comparable to one who spoke to him directly, and those witnesses will be liable. The Tanna teaches that until he specifies to whom he's directing his demand, he does not render those witnesses obligated to take an oath of testimony. The Gemara notes, this is also taught in a Braita. Tanya Nami Hachi. Rashi explains that the proof is from the language, Might one have thought that the same is true even if he said, I administer an oath to everyone who is standing here that you will come and testify on my behalf? It's specifically because the plaintiff said, those standing here, that the witnesses are liable, as the witnesses are standing beside him. But if the plaintiff did not say those standing here, unless he specifically designated the witnesses they are exempt, the Ran disagrees and holds that the distinction in the Braita is not whether or not he said those standing here. Rather, the distinction is whether or not he said everyone. If he administered the oath in general to those standing in the synagogue with the knowledge that only some of them have knowledge of the matter, it's clear that his reference is not to all the individuals, and he did not specify any of them. But if he stated to everyone who is standing here in the synagogue, he intends to administer an oath to everyone standing in the synagogue, and not merely to those standing next to him. As Rashi explains, it's as though he specified them in Tos Chaim. The Ran cites proof for this interpretation from the Rambam. There are practical ramifications of this interpretation. Can one administer an oath of testimony when he is uncertain whether a specific individual or group of individuals have knowledge of the matter? To the Ran. If one saw a group of people standing, and his witnesses were among them, and he said to the entire group, I administer an oath to you that if you know testimony relevant to me, you will come and testify on my behalf. In such a case, one might have thought that they would be liable. The verse states, and he is a witness, verse 5:1. And in this case, he did not specify his witnesses, therefore they are not liable. One might have thought that the halacha is the same, even if he said, administer an oath to everyone who is standing here, and you will come and testify on my behalf. The verse states, and he is a witness, Leviticus 5:1. And in this case, although he spoke to a group, he specified his witnesses, therefore they are liable. The Mishnah teaches that if one said to two individuals, I administer an oath to you, if they know testimony relevant to him based on hearsay, or if one of the witnesses is found to be a relative or disqualified, they are exempt. The Gemara cites that which the sages taught. If one said to two individuals, I administer an oath to you, so and so and so, so, that if you know testimony relevant to me, you will come and testify on my behalf, and they know testimony relevant to him based on hearsay testimony, or if one of the witnesses is a relative or disqualified, in such a case one might have thought that they would be liable. The verse states, if he did not state it, then he shall bear his iniquity. Leviticus 5:1, teaching that it is with regard to those eligible for the statement of testimony that the verse is speaking, not to those who are ineligible. The Mishnah teaches the plaintiff sent the demand for the testimony by means of his slave, e.g., the sages taught. If the plaintiff sent the demand for the testimony by means of his slave, or in the case where the defendant said to the witnesses, I administer an oath to you that if you know any testimony relevant to the plaintiff, you will come and testify on his behalf, might one have thought that they would be liable? The verse states, if he does not state it, then he shall bear his iniquity. In Leviticus 5:1, therefore they are not liable. And we'll ask, what is the biblical derivation that leads to that conclusion? Rabbi Lazar said, the derivation is based on the fact that it is written, Im lo yagid. In the verse, the word lo is spelled lamed vav aleph, and interpreted as both not, spelled lamed aleph, and to him it's spelled lamed vav. It is derived, if the witness knows who knows the testimony does not state it to the plaintiff, he should bear his iniquity and he is liable. But if he does not state it to another, he is exempt. Let's see in the footnote. Im lo yagid, if he does not state. According to the traditional text of the Bible, the word lo, meaning no, is spelled in several places lamed vav, aleph, which is a combination of the terms no, spelled lamed aleph, and to him, spelled lamed vav. The verse is interpreted as though it is written, if the witness who has knowledge of the matter does not state it to him, the plaintiff, he should bear his iniquity, and he is liable. And if he does not state it to another, he is exempt. See Rashi and the Rambam's commentary on the Mishnah. The Mishnah discusses the formula of an oath of testimony. If the plaintiff said to the witness, I administer an oath to you concerning your refusal to testify, if you do not come and testify on my behalf, or even if he said, I command you, if one said to witnesses, I command you with an oath, or I bind you with an oath, if he invoked the name of God or the appellation of God, he is liable for taking a false oath of testimony, in accordance with the Mishnah and the explanation of Abaye. I'm going to say Shevuot 9:11. Or I bind you, although he did not employ an unequivocal formula of an oath, these witnesses are liable for taking a false oath of testimony. If one administered the oath to the witnesses in the name of heaven and in the name of earth, these witnesses are exempt from liability for taking a false oath of testimony, as that is not an oath in the name of God. If one administered the oath to the witnesses in the name of Aleph, Dalet, But Aleph Dales, actually, others explain that Aleph Daled is an abbreviation of Adonai, and Yud Hey is an abbreviation of Tetragrammaton. Others explain that the reference in the Mishnah is to a case where the plaintiff states only half the name. Due sanctity of the name, there is sanctity even in half of the name, and that's from the written Tosfos Harosh. Adonai, in the name of Yud Hey, the Tetragrammaton, in the name of the Almighty Shaddai, in the name of the Lord of hosts, Shevuot, in the name of the great and compassionate one, in the name of he who is slow to anger, in the name of one who is abounding in loving kindness, in the name of any of the appellations of God. Whether one administers an oath invoking the name of God, or with any of the appellations of God, e.g., if he administers an oath in the name of he whose name is gracious, it is a full-fledged oath. Rambam Sefer Shevuot 2:2-4. Even though he did not mention the ineffable name of God, those witnesses are liable for taking a photo of testimony. One who curses God, all these curses are prohibited by Torah law, and in some of them the punishment is written. And in the case of one who curses God, it is stated, each and every man who shall curse his God shall bear his sin. And he who blasphemes the name of the Lord shall be put to death. All the congregation shall stone him. This is 24:15-16. And in the case of one who curses his mother or father, it is stated, and he who curses his father or mother shall be put to death. Exodus 21:17. The prohibition against cursing another is derived from the verse, "Do not curse to death." Leviticus 19:14, which the sages interpreted to include all Jews. Punishment for violating the prohibition is lashes. It is for violating a standard Torah prohibition. Prohibition against cursing oneself is derived from the verse, "Only observe yourself and keep your soul diligently," in Numbers 4:9. God employing any of these names. One who curses God is liable to be executed through stoning only who invokes the name Aleph Dalet Nun Yud and then curses it employing one of the names that may not be erased. One is liable to be executed through stoning for invoking the name Aleph Dalet Nun Yud, while if one invokes any of the appellations of God, he is liable to receive lashes in accordance with the opinion of the rabbis. Some hold that one is liable to be executed only if he invokes the ineffable name of God. According to the Rambam, one is liable to be executed through stoning for invoking either Aleph Dalet Nun Yud or Tetragrammaton. That's from the Rambam Sefer Hamata, Hilchot Avodah Zarah 2:7. Named appellation of God is liable to be executed through stoning. This is the statement of Rabbi Meir. And the rabbi team is exempt, as they hold that one is liable for cursing God only if he employs the ineffable name of God. One who curses his father or mother, one who curses his father or his mother, even after their death, is liable to execute through stoning if he did so in the presence of witnesses and with forewarning. This is a halacha whether it is a son or a daughter who curses his or her parent. In what case are these matters stated? They are stated in a case where one curses them invoking the names of God. But if he curses them invoking an appellation, he is liable to receive lashes for violating a prohibition, like one who curses any Jew in accordance with the opinion of the rabbis. Sefer Shevuot Hilchot Mamrim 41:1. Employing any of these names or appellations of God is liable to execute through stoning. This is the statement of Rabbi Meir, and the rabbis deem him exempt, as they hold that one is liable for cursing his father and his mother only if he employs the ineffable name of God. One who curses himself or another. And Kala Asma Chaveru. One who curses another Jew curses himself is the Torah invoking the name of God or an appellation of God or one of the names the Gentiles use for God is liable to receive lashes if he did so in the presence of witnesses and with forewarning. The Rime is cited in the Jewish Talmud writes that one who is liable only when invoking the ineffable name of God. And say for Shevuot Hilchot Sanhedrin 26:3 and the Ketzer Mishnah there Shulchan Aruch Mishpat 27:1. It is prohibited by Torah to curse any Jew who observes the Torah, even if the individual is that one is cursing is unaware, e.g. because he is deaf. Leviticus 19:14. One who curses another Jew invoking God's name is liable to receive lashes by Torah. Deuteronomy 3b. Employing any of these names or appellations of God by its prohibition. If one says, "The Lord God shall strike you," in Deuteronomy 28:22. And likewise, if one says, "God shall strike you if you do not come to testify," that is a curse that is written in the Torah, and in such a case, one is certainly liable if he fails to testify. If one says to the witnesses, "God shall not strike you," If one curses another without invoking the name of God, or an appellation, or if the curse was inferred from a statement, e.g., may so-and-so not be blessed by God, he is not flogged, in accordance with the opinion of the rabbis. Nevertheless, it is prohibited to conduct oneself in this manner. Roman Sefer Shevuot in Hilchos Sanhedrin 26:4, Shulchan Aruch Mishpat 27:2. Or God shall bless you, or God shall benefit you if you come and testify, but by many deems him liable. As one may infer from that statement that if he fails to testify, God will strike him, or will he not bless or benefit him, and the rabbis deem him exempt because the curse is not explicitly stated. The Mishnah teacher is that plaintiff said to the witnesses, I administer an oath to you, I command you, or I bind you. These witnesses are liable for taking a false oath of testimony. The Gemara asked, what is the plaintiff saying? He merely said that he administered an oath, and he did not say in the name of what he is administering the oath. But Yehuda said, this is what the plaintiff is saying, I administer an oath to you with the oath mentioned in the Torah, I command you with the command mentioned in the Torah, I bind you with the bond mentioned in the Torah, and in the Torah all of these include mention of the name of God. Rabbi said to Rav Yehuda, according to that interpretation concerning that which Rabbi Chias teaches, that if the plaintiff said to the witnesses, I chain you, these witnesses are liable for taking a false oath of testimony. Is chaining written in the Torah? Apparently the reference in the Mishnah and the Baita is not similar to the language in the Torah. Rather, Rabbi said that this is what the plaintiff is saying. I administer an oath to you with an oath. I command. According to Rashi, it appears that when employing any of these formulas, the plaintiff must invoke the name of God, and when Rabbi Yehuda says with an oath, it means in the name of God. According to this interpretation, were the plaintiff to say with an oath without invoking God's name, the witnesses would be liable. The Ran explains that this is based on the fact that the primary form of oath mentioned in the Torah is an oath in the name of God, as it is written, you should not take an oath in my name falsely in Leviticus 19:12. And you should not take the name of the Lord your God in vain, Exodus 26. Rashi and others hold that there are two possible forms of an oath, one invoking the name of God and the other mentioning with an oath, even without invoking the name of God. See Kuntras Harayot. You with an oath, I will bind you with an oath, I will chain you with an oath. The witnesses are liable in these cases, provided that the plaintiff mentions an oath. The Mishnah teaches, if one administered an oath to the witnesses in the name of Aleph Dalet, in the name of Yud Hey, in the name of the Almighty Shaddai, in the name of the Lord of hosts Shevuot, in the name of the gracious and compassionate one, in the name of he who is slow to anger, or in the name of he who is abounding in loving kindness, these witnesses are liable for taking a false oath of testimony. Is that to say that gracious and compassionate are sacred names? The Gemara raises a contradiction from Baita. There are names of God that may be erased, and there are names of God which may not be erased. The sage interpreted in the first 4 verses in Deuteronomy chapter 12 as the prohibition against destroying the written name of God, although the Gemara here repeatedly employs the term erase, any act that results in impugning the name of God is prohibited, including burning or ripping paper or parchment on which the names are written, or painting over the names. The Gemara here discusses which names are included in this prohibition. Because of this prohibition, there is a long-standing Jewish custom that sacred texts like the Bible or the prayer book in which the names of God are written that become worn or damaged are not discarded, rather they are interred in the ground or stored in an attic or cellar in the synagogue. Jews inherit sanctity. These are names that may not be erased. For example, several variations of the name God Elokim, Kel, Elka, Elkecha, with the second person singular suffix Elokim, Elkechem, with the second person plural suffix I shall be, that shall be, Daled Yud Hey, Almighty Shaddai, Lord of hosts Shevuot. These names may not be erased. It's forbidden to erase even a single letter from any of the seven names that may not be erased. These are the 7 names: the Tetragrammaton, Aleph Daled Nun Yud, Kel, Elokah, Elokim, Shaddai, Shevuot. Based on one of the very readings cited by the Rambam, the same is true for Elokai. Others cite the very reading that the same is true for Eyer Asher Yed from the Torah. See the Ketef Mishnah and the Gra, who cite additional variant readings. The Shach writes that if there is a non-sacred name whose spelling is identical to that of a sacred name, it may be erased. Likewise, a sacred name that is not written for the purpose of sanctity may be erased in order to amend it. If the intent is not to amend the text, one must excise the name and inter it. If the name is written for the purpose of sanctity, it is prohibited to excise the name from the parchment and inter it, even if its intent is to repair the parchment. Rambam Sefer Amada Hechot, you study Torah 6:4, Shulchan Aruch Yodea 276:9. But the adjectives that describe the Holy One, blessed be He, e.g. the great, the mighty, the awesome, the prodigious, the powerful, the courageous, the strong, the gracious, compassionate, slow to anger, or abounding in loving kindness, these may be erased. The halacha states of the adjectives and appellations of God, e.g. Chanan and Rachum, is like that of any other word in the Bible that one may erase them. I'm going to say from Mother Hilchot Yisodei Torah 6:5. Apparently, gracious and compassionate are adjectives and not actual names of God. How then does an oath or curse in the name of grace and compassion take effect? Abai said in the Mishnah, it is with regard to one who administers an oath or curse in the name of He who is gracious. Thank you for listening and all the best. Bye.